everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty here at iExamBee. Welcome to the mock test series that we have started at LegalBee exclusively. In this video series, we are discussing questions from different subjects and different topics as well. So stay tuned to LegalBee. अगर आपने बाकी के videos miss किए हैं, I would request everybody to go and check the playlist section of LegalBee channel. ये सारे वीडियोस तो आप देख ही लेना. Other than this, I would suggest you all to go through the other videos that are strategic videos, content-based videos that we have at LegalBee, which will definitely help you in preparing for your examinations. Other than this, if you have not checked out our courses, visit our website www.iexambee.com and check all the courses that are available, free mock tests that are available for different examinations like judiciary, UGC net examination, अभी SEBI legal का भी examination expected है. उससे related भी अगर आपके कोई भी queries हैं, you can write to us in the comment section of this video. You can also email us on hello@iexambee.com and call on this number 920-5524028 for more details. The topic that I have started for discussion is Arbitration and Conciliation Act. Important questions I'm going to take up. This is the second part of the video series for Arbitration and Conciliation Act. इसका फर्स्ट पार्ट जिसमें मैंने 10 क्वेश्चंस डिस्कस किए हैं जो काफ़ी इनोवेटिव क्वेश्चंस भी है एंड काफ़ी इंपॉर्टेंट भी है, वो वीडियो भी आप प्लेलिस्ट में जाके एक्सेस कर सकते हैं एंड यू कैन चेक ऑल दोज क्वेश्चंस फॉर प्रैक्टिस. SEBI graded legal online course is also available at iExamBee's website. These are the details of the expert faculty here at iExamBee. If you have not checked the details, do check it fast and prepare 50% faster with iExamBee. Let us see what is the first question. If a party approaches before court in spite of having an arbitration agreement, then in such kind of conditions, this is a very disputable area of arbitration actually. इसलिए यहाँ से क्वेश्चन पिक करना बहुत ज़रूरी था. That's why I have picked it as the first question of this video only. इसको आप अच्छे से समझ लीजिए कि कोर्ट का इंटरवेंशन किस तरीके से होगा आर्बिट्रेशन डिस्प्यूट्स में. अगर पार्टी के पास ऑलरेडी आर्बिट्रेशन अग्रीमेंट है एंड इफ स्टिल इट अप्रोचेज द कोर्ट, then in that case, court may refer matter back for arbitration. Court may take up the matter for adjudication. Court shall refer matter for arbitration if a valid arbitration exists. Can you see the difference in the words may and shall over here? Court may refer matter for arbitration even if there does not exist arbitration agreement. It is up to the parties that they may go for arbitration or they may continue with litigation. So these are the 5 options in which you have to choose the best one. And the correct answer is C. Court shall refer matter for arbitration if a valid arbitration exists. And this has been picked from section 8, power to refer parties to arbitration where there is an arbitration agreement. So in such kind of cases, the court shall do that. Because arbitration agreement is existing, so it is necessary that the matter should be referred for arbitration and the court is having that power to do that. Second question, which of the following is the wrong combination of number of arbitrators in an arbitral tribunal? I hope everybody knows what is an arbitral tribunal. So what is the wrong combination of number of arbitrators? We need to see that. This is also an innovative question. जैसे मैंने आपको कहा कुछ questions innovative है, इससे हमारी thinking भी बढ़ जाती है that we need to think out of the box when we are solving the MCQs. So wrong combination of number of arbitrators is going to be definitely A. Because all these are odd numbers and this is an even number. तो arbitral tribunal में even number of arbitrators नहीं हो सकते because we need to come out with a judgment, with an adjudication. So the decision has to be passed in ratio form sometimes. ऐसा होता है, judges का भी आपने देखा होगा. So the number of arbitrators should not be even over here. This is mentioned in section 10. Parties are free to determine the arbitrators and the arbitral tribunal can consist of sole arbitrator also, but the number of arbitrators should not be an even number, ऐसा clearly mentioned. In case of 3 arbitrators, appointment of the presiding arbitrator can be made by presiding arbitrator का appointment कौन करेगा? This is what is the question. अगेन अ वेरी इजी क्वेश्चन. ये क्वेश्चंस ऐसे हैं कि अगर आपको पता है बहुत जल्दी इसमें स्कोर कर सकते हैं एंड यू कैन एक्चुअली स्कोर ऑल्सो एंड यू कैन एक्चुअली वेरी इजीली स्टडी एंड रिमेंबर दीज कंसेप्ट. मतलब ये ऐसे कंसेप्ट हैं जो बहुत जल्दी आप पढ़ सकते हो. So that's why it becomes very scoring topic for you. Arbitration is a scoring topic in any competitive examination. Answer is D over here. Two appointed arbitrators cumulatively, or the parties are free to determine. Okay. Section 11 talks about this point. Appointment of arbitrators. Court can provide assistance in taking evidence to arbitral tribunal. Yes, this is true. Court can provide assistance in all cases, or when the arbitral tribunal is making a request, or when any party with prior approval of arbitral tribunal makes such kind of application, no evidence is taken in arbitration proceedings, court may directly call upon the matter before itself. So in what cases actually the court can take evidence? That is what is the question that has been asked. Very nice conceptual clarity you can have in such a way actually. इसलिए मैं आपसे कह रही हूँ कि बाकी के वीडियोस भी आप लोग देख लीजिए. अगर आपने इस सीरीज़ के वीडियोस मिस किए हैं तो it can be very helpful for you. Correct answer is C. When any party with prior approval of arbitral tribunal makes an application that it requires assistance, then only court will intervene. Section 27 of the Arbitration and Conciliation Act 1996 talks about this. Fast track procedure is covered under which section of Arbitration and Conciliation Act 1996? Section 29, Section 29A, Section 29B, Section 29C, Section 30. ये सेक्शन बेस्ड क्वेश्चंस भी हमें क्यों पढ़ने चाहिए ताकि हमें सेक्शंस भी याद रहे. सो फास्ट ट्रैक प्रोसीजर समथिंग विच इज़ एन इम्पॉर्टेंट एरिया फ्रॉम आर्बिट्रेशन एक्ट एंड इट इज़ एन अमेंडेड वन. सो आंसर इनमें से ही होना चाहिए. करेक्ट आंसर इज सी, दैट इज सेक्शन 29B. टॉक्स अबाउट फास्ट ट्रैक प्रोसीजर and I would request everybody to go through this section A as well as B. Parties may agree to resolve the dispute by fast track procedure at any time during the arbitration proceedings, any time before the constitution of the arbitral tribunal, and any time the constitution of arbitral tribunal, at any time even after constitution of arbitral tribunal. B or C, that is at any time before constitution of arbitral tribunal or at the time of constitution of arbitral tribunal. मतलब इसका मतलब क्या निकलेगा कि constitution of arbitral tribunal होने के बाद नहीं हो सकता, या फिर any time during the arbitration proceedings. This is also something which is an important area. Fast track procedure के लिए कब जा सकते हैं? So the answer is E, B or C. At any time before the constitution of arbitral tribunal or at the time of constitution of arbitral tribunal. This is also directly mentioned in section 29B. Parties may at any stage either before or at the time of appointment of arbitral tribunal resolve their dispute by fast track procedure. ये पहले ही clear हो जाना चाहिए. अगर arbitral tribunal constitute हो गया तो after that you come. The form of arbitral tribunal award is discussed where? Arbitral award, an important area, but the section is also important here and a topic also. जैसे कि क्या contents होनी चाहिए arbitral award में, ये भी आपको पता होना चाहिए. What is the enforceability? What is the effect status of arbitral award? So the section is section 31. Section 31 deals with form and contents of arbitral award. During the arbitral proceedings, interim measures can be ordered by arbitral tribunal. Yes, in the previous video also we discussed this. Interim measures तो हम order कर ही सकते हैं arbitral tribunal के through. In some cases, court can also do that. But under which provision? Now this question is very easy, but when you see the options, you may get confused. As under section 17, suo motu only in some cases the tribunal requires, if the party is making an application, A and C, A and B or C. So now they have given you some situations and that has made the question a bit different. And that should be known by everybody कि actually इसका आंसर है क्या. Answer is D. As under section 17 of Arbitration and Conciliation Act 1996 and if the party makes an application to the tribunal, suo motu का यहाँ पे कोई भी role नहीं है. Section 17 talks about this. You should remember the section also over here. Arbitral tribunal may meet at any place for dash in conduct of proceedings. Now it can meet at any places, but for what purposes? Consultation, hearing witnesses, experts or parties if you want to examine them, if you want to inspect the documents or goods, or at all of the above. ये भी थोड़ा सा क्वेश्चन ट्विस्ट करके दिया हुआ है, और अगर आपका कंसेप्ट क्लियर है तो आपको कंफ्यूज नहीं होना है. आंसर इज ई, at any place for any of all these, because all these are a part of the conduct of proceedings, right? So you can do all these things. Arbitral tribunal can meet at any place. This is what is the flexibility in the procedure, right? So all of the above is the correct answer. Section 20 talks about place of arbitration. यहाँ से एक और एक famous question बन सकता है, that who is going to agree on the place of arbitration. So you have to choose that the parties are free to agree on the place of arbitration. लैंग्वेज से रिलेटेड भी इस तरीके का क्वेश्चन बन सकता है. लास्ट क्वेश्चन, एन आर्बिट्रल ट्रिब्यूनल कैन नॉट टेक अप बिफोर इट सेट ऑफ एंड काउंटर क्लेम, क्रिमिनल कंप्लेंट्स दैट आर रिलेटेड टू आर्बिट्रेशन अग्रीमेंट, स्टेटमेंट्स ऑफ क्लेम एंड डिफेंस, एविडेंस रिलेटिंग टू द डिस्प्यूट, ए एंड बी, सेट ऑफ एंड काउंटर क्लेम एंड क्रिमिनल कंप्लेंट्स रिलेटेड टू आर्बिट्रेशन अग्रीमेंट. ये क्वेश्चन काफ़ी मुझे अच्छा लगता है बिकॉज द वे इट हैज़ बीन फ्रेम्ड इज ऑल्सो वेरी नाइस. Now you have to think and you have to answer that what are the limitations of an arbitral tribunal, what it cannot take up before itself, right? So the answer is B, criminal complaints related to the arbitration agreement. Statements of claim and defense तो ले ही सकते हैं, obviously that is the main thing. And respondent may also take up set off and counter claim that can also be pleaded. ये भी सिविल लॉ का पार्ट है, CBC में आपने पढ़ा होगा. इसका यहाँ पे मैंने अमेंडेड सेक्शन भी दिया है, सेक्शन 23 तो है ही. इन दैट 2A हैज़ बीन अमेंडेड एंड एडेड दैट द रिस्पॉन्डेंट इन सपोर्ट ऑफ हिज केस में ऑल्सो सबमिट अ काउंटर क्लेम और प्लीड अ सेट ऑफ. सो ये दोनों ऑप्शन सही है. एविडेंस तो ऑब्वियसली ले ही सकता है. सो व्हाट इज द थिंग विच इज एलिमिनेटेड हियर इज क्रिमिनल कंप्लेंट्स रिलेटेड टू आर्बिट्रेशन अग्रीमेंट. आर्बिट्रेशन अग्रीमेंट से रिलेटेड क्रिमिनल कंप्लेंट्स फाइल नहीं हो सकती बिकॉज द आर्बिट्रल ट्रिब्यूनल इज नॉट हैविंग पावर्स फॉर दैट. दिस इज ऑल्सो अ नाइस क्वेश्चन. I hope you all are liking these questions and practicing them regularly, because practicing questions is a very good type of revision also, and it helps you become exam ready अगर आप कोई competitive exams के लिए prepare कर रहे हैं. If you have any queries or you want anything from us at relating to content strategy for any exam or any guidance, you can reach out to us directly in the comment section of this video. Prepare 50% faster with iExamBee, and don't forget to subscribe to LegalBee. Thank you everybody. Have a good day.